Good morning, everyone. I'm going to put this here. Or not. My name is Rubin Mukkam-Owuor, and I am a director at JMiles Co. As Mercy has said, we specialize purely in arbitration, and I hope I can bring some of that expertise to you today. So here's a scenario. You're a business and you've encountered a dispute, whether it's with a co-shareholder or a contractual party or an aggrieved employee, let's say. Now, you are considering arbitration, right? You might have already tried negotiations, mediation, which have failed, and now you're faced with arbitration. Your board of directors might ask you, what do you stand to gain from commencing an arbitration? For example, are you seeking monetary relief? Are you seeking some kind of compensation from the other side? Are you seeking a declaration, perhaps, where you want a tribunal to say, no, this shareholder has no claim as to the assets of this company, for example? So yes, what do you stand to gain from an arbitration? Your board of directors might also ask you, what are the merits of this case? What is the chance that, of success? What is the chance that we'll actually win this arbitration? And they might also ask you what the cost of this entire process is going to be, which can be significant in arbitration. Now, it might seem obvious, but if you are the successful party in an arbitration, you can actually get some of your costs of having had to go through the arbitration process from the tribunal. You can ask the tribunal to award you costs. Now, how the tribunal exercises its discretion on how to award those costs depends on a couple of things. It depends on the arbitration rules of the institution that you might be using, if you are using an institution. It might depend on the law of the seat of your arbitration. And it also might depend on the national law of the country in which you're doing your arbitration. Now, I'm going to take a English law focus to my answer to this question. Now, the general principle, and you've heard this phrase before in previous panels, is that costs follow the event. What is the event? The event is success, essentially. Which party in the arbitration was more successful than the other? And that is, it seems like an easy question, but really is quite difficult to determine sometimes. For example, what if you're half successful? What if out of 5 claims that you made, you were successful on 3 and unsuccessful on 2? And also, what if of the 3 claims, actually you spent very little time, or the tribunal spent very little time hearing from you and the other side and making their determination on those 3 claims. But on the 2 that you lost, that's actually where you spent 4 days of arbitration and lots of witnesses on. So all of these factors go into the tribunal's decision on how much costs to award. Now, it's not a scientific exercise, as you can tell. It's very much based on the amount of time you've spent determining a claim, for example, the conduct of the parties. All of that actually comes into play when a tribunal makes its decision. It's a common sense exercise. Now, okay, so let's say you've worked out this party is 100% successful, or this party has been 60% successful. Now you come to what costs can I actually get back, right? Because you may spend $1 million, but perhaps some of the heads of those costs are not recoverable. So here I'm gonna try and do a little pop quiz. I'm gonna mention a couple of types of costs, and I'm gonna ask you guys to just raise your hand and tell me if you think those costs are recoverable. Lawyers' fees, so solicitors, counsel, and any lawyers that you ask to represent you. How many of you think that that's recoverable? All right, we have a few hands. All right, what about expert witnesses? Witnesses that you've asked to give evidence on a very specific and technical point of the dispute, which the arbitrator might need some help on. How many of you think that's recoverable? Yep, lots of you. What about the charges of translators and transcribers? Yep. Hearing venue expenses, right? Flights, accommodation. Okay, we have some tentative. And let's say photocopying. Yeah, yes, okay. What about pre-arbitration costs? Let's say before the dispute, you did a bit of investigation. What assets does the other side have? Is there something I can enforce against? What are those recoverable? Ooh, nobody. Okay. So the news is that yes, it is recoverable. Pre-arbitration costs are actually recoverable if the dispute was sufficiently in prospect, meaning it was pretty clear the dispute was going to arise and that it was going to go to arbitration. Then you can actually claim your pre-arbitration costs. Travel and accommodation is actually a disbursement and certainly can be recovered. So there are a lot of, and then actually even your costs of trying to figure out if your costs are recoverable are also recoverable. So you can actually get a large part of the costs that you expend in trying to resolve a dispute back. And the rationale for that is that if you're successful, then the other party shouldn't have put you through the entire arbitration process to begin with. So yeah, so you know what? Actually, you can get quite a bit of your costs back. So you have figured out who's successful. You also now know that a large part of your costs that you spent on travel and accommodation, even investigations pre the dispute, all of that is actually recoverable. Now you come to a question of proportionality. And Danga had spoken about this in the previous panel. Let's say your dispute is $30,000 in value, but your arbitration costs are $1 million. Now, that is completely disproportionate, and you wouldn't be able to, of course, recover the full $1 million that you spent in arbitration because it would be completely out of whack. Now, they're proportionate, and how do you determine the proportionality? It's whether it's proportionate in relation to the sums in issue in the proceedings. And that would include actually the value of non-monetary claims. So if your claims were for a declaration, for example, that would protect your brand reputation, then that value would be taken into account in determining proportionality. The complexity of the case, were the arguments very convoluted and very technical and very legal, that would come into play as well. So then you actually have, so let's say your costs are indeed reasonably incurred and they are proportional, and that you are successful. Then the arbitrator is faced with making a decision on how much of those costs to give back to you. In reality, even though you are 100% successful and your costs were proportional and reasonably incurred, and all of your costs were indeed recoverable, then, so even in such cases, arbitrators, if they're making a summary assessment and not a detailed assessment of your costs, might nevertheless discount the total cost that you incurred by, say, 30%. 30% is actually quite a common discount that arbitrators apply to costs. And it may be that the arbitrator decides not to deal with issues of costs because it doesn't feel that it has the technical capacity in which to do so, in which case they would refer those questions to a court. Or it may decide to go ahead and in that instance make a summary judgment. Sorry, I will refrain from using the term summary judgment because it has other implications, but a summary assessment of costs. So it really depends on the style of the arbitrator. I've had cases where the arbitrator gives 100% costs, you know, in the style of indemnity costs, if we're referring to litigation, or an arbitrator that has said, well, I agree with you, you've won the case, your costs are reasonable, they're proportionate to the claim, but I'm still going to discount them by 30%. So these are the realities I think that a business faces when it faces the question of, do I engage in arbitration or do I try and settle? Do I try and negotiate with the other side? This is, I would say, a very general commentary. I've tried to stick to 10 minutes of your time, and I will take any questions if there are. All right, I think we are okay. Thank you so much for your time. And if you have any questions at all, you know where to find me.